5 seconds. Start. From a perusal of the article extracted above, it is clear that the execution of any decree or order of a civil court contains two limbs indicating the time from which the period of limitation begins to run. Stop. When the decree or order becomes unforeseeable and where the decree or any subsequent order directs any payment of money or the delivery of any property to be made at a certain date or at recurring periods when default in making the payment or delivery in respect of which execution is sought takes place. Stop. The proviso says that there shall be no period of limitation for enforcement or execution of decree granting a perpetual injunction. Stop. We are concerned here that the first of the above mentioned starting points, namely when the decree or an order becomes unforeseeable. Stop para. A decree or order is said to be unforeseeable when it is executable. Stop. For a decree to be executable, it must be in existence. Stop. A decree would be deemed to come into existence immediately on the pronouncement of the judgment. Stop. But it is a fact of which judicial notice may be taken of that drawing up and signing of the decree takes some time after the pronouncement of the judgment. The Code of Civil Procedure itself enjoins that the decree shall be drawn up expeditiously and in any case within 15 days from the date of the judgment. Stop. If the decree were to bear the date when it is actually drawn up and signed, then that date will be incompatible with the date of the judgment. Stop. This incongruity is taken care of by Order 20, Rule 7 CPC, which inter alia provides that the decree shall bear the date and the day on which the judgment was pronounced. Stop. The fixation of periods of limitation are bound to be to some extent arbitrary and may at times result in hardship. Stop. But in construing some provisions, equitable considerations are out of place and the strict grammatical meaning of the words is the only safe guide. Stop. The decree was unforeseeable immediately after the date specified in the decree, that is 23/9/1966, for the decree holder to deposit the consideration money. Stop para. If the direction given in the decree to the judgment debtor to measure and demarcate the land by that date was not complied with, the decree holder was free to execute the decree. Stop. The steps to be taken by the decree holder in this regard are provided in Order 21, Rule 34 within bracket 1 CPC. Stop.